Well, artificial intelligence and its use by businesses continues to be a hot topic, and that's clear from the level of interest even in this webinar. With so many different AI offerings on the market, it's important that businesses understand the different ways that AI can be used, the latest legal developments, and the potential risks involved. Now, this webinar follows on from our webinar earlier this year, exploring the top issues to consider when using AI. And what I will be doing in the easy role is putting questions on the latest industry and legal developments to the following panel of experts. First, Dr. Richard Marshall, Chief Analyst and AI Advisor of Concept Gap. Richard combines experience in delivery of AI with acting as an expert witness in software disputes. He has applied this experience to developing an understanding of the impact of AI on the evolution of disputes, as AI is embedded in every system we use. Next, Monica Connolly, a legal director in our commercial dispute resolution team, who specialises in advising businesses on IP and technology disputes. And finally, Ali Burr, associate in our commercial practice, who specialises in matters relating to intellectual property, technology and outsourcing, commercial contracts and data protection, and who sits on the Brody's AI task force. And we may ask Ali a bit more about that at some stage during the Q&A. So I think our numbers are now looking healthy enough for me to start putting questions to people. And just because Richard doesn't actually work in my team, I'm going to pick on Richard first as the special guest expert. I apologize in advance for that, Richard, but I hope that's okay.
Absolutely.
So the first question that I would like to ask, as we're looking to try and kind of set the scene a bit here, is: are you able, Richard, to share some of the most innovative and impactful AI use cases that you've encountered recently, and also maybe say a bit about what industries that you're aware of that are leading the way in terms of adopting some of these technologies?
Well, I was going to start with borrowing a expression from showbiz, which is it takes 30 years to be an overnight success. And I think that's very much the case of AI, because a lot of people are thinking of generative AI, but there's lots of other kinds of AI. And a lot of this stuff has been around since the 1970s, and there's lots of really interesting things that have been going on in manufacturing, expert systems that will manage safety triggers and things like that, as well as more recently some of the very clever predictive maintenance systems that you get with digital twins of equipment in manufacturing, etc. So there are a lot of new things happening, but we shouldn't ignore the fact that there's a long history here of stuff that's actually really interesting. I mean, you could even consider things like autocorrect, and it may get things wrong, but it's very convenient when it works. And that's been around for a while. So I think it's interesting to look. Let's start off looking at some of the technology. So everybody's excited about generative AI, understandably, and a lot of that's driven by the transformer technology underneath LLMs, large language models. But LLMs are very expensive to train, very expensive to operate, and they don't necessarily get specializations correct for because they're general. So there's a lot of interesting stuff that is expanding out of that. So you get SLM, small language models that can be specialized in it. So you could imagine having a dedicated SLM around your own legal base, for example, or if you're working in a different area that, for example, software engineering, you might be looking at an SLM that's been trained on your code base, which is something that Google's been looking at with Gemini. There's also agents, and there's a whole bunch of other things coming along there that are going to deploy this generative technology in very, very interesting ways. So I think that it's a very exciting future, and I think that we are probably at peak hype, but we are definitely not at peak capability. The capability isn't there yet. Indeed, there's a lot of people out there saying that the killer apps of generative are not there yet. I'm not sure I agree with that, but they are beginning to emerge. So thinking about some industries that are out there, one of the very interesting ones is actually cybersecurity. I was at a Cisco event recently where the president of Cisco Europe said that the killer application of AI was creating viruses and phishing emails. And there's a large degree of truth in the fact that cybersecurity has AI working full power on both sides, so that it's actually very good at creating ludicrously plausible phishing messages that everybody needs to be very careful about. It's also very good at creating targeted viruses or attack paths. But on the other hand, the security vendors out there are using AI to detect these actions and come up with playbooks automatically and be which counters each other out. So that's an area where things are really very exciting. I mentioned software development. There's a lot of really interesting stuff happening in software development where it's the tools at this stage are like having a kind of coding buddy that will do bits and pieces for you. They're not really quite there yet at building large, complex systems. But if you've got small bits of code that you need written, boom, it'll do it for you. They do have a tendency to invent things. The analogy that I use is they're like having an intern or a junior developer working for you who's trying to show off all these clever things it knows, but doesn't quite get the problem right for the moment. So that's an area that's really exciting. Outside of that, pharma is doing a huge amount of really, really interesting things. There are some emerging tech in there that is going to be completely transformative, not just in designing the pharmaceuticals, but also in go-to-market. And there's actually a lot of really, really interesting stuff that's being developed. I mean, insurance is another area. So I've seen insurance capabilities where you can say, I've got a warehouse in Florida, there's a storm coming in, what is my coverage? And it knows who you are and it can look up your policies and extract the details and just answer that very efficiently. And the last example I'm going to call out is one that I really like is one of the things about AI is that it can let you do things that you couldn't do before economically. So there's some very cool technology out there that will let you assess 100% of your contact center conversations, whether they be voice or text or whatever it is. Previously, these would only be monitored by like 10% maximum by manager. And the AI can look at this and do 100% because it scales up to that. And the systems out there have already detected some incredible things that the individual agents aren't picking up because it has this overall view of the picture. And this notion that we are no longer constrained by the number of people we can deploy in a project, but we can roll out hundreds of agents, virtual agents of all sorts, synthetic people. Those are going to be transformative, and it's very early days for that. So I think that's the most exciting space.
It's fascinating, Richard. Thank you. And of all the answers I expected to what organizations are currently making the best use of AI, organized crime was not the one I expected to be top of the list. But there you go.
Sadly,
That's
it's very
yeah.
much the case that it's happening,
we,
and
we are all more than aware of that. Very
glad to
true.
hear it.
I think I'll stick with you just with a kind of follow up really on that, Richard, but kind of applying this now into some of the decision making that businesses should be looking at. So if we're looking at, various clients or businesses who are considering what to do in relation to AI and are considering perhaps building their own AI products in-house or purchasing third-party solutions, what do you think are the key factors that they should be weighing up when they're making that sort of decision?
Well, the first one has to be talent availability. If you can't hire the talent to do the work, you're going to be struggling. So, what kind of talent do you need? You need people who understand data and data scientists, and that's mainly maths, complex maths. I invite anybody to look at some of the maths involved in the training of AI models, and if your brain doesn't explode, then you're probably in a good position to be a data scientist. Also, there's a lot of programming involved in building the structure around about it, the scaffolding that's going to hold that. So if you look at an AI system, it's different from conventional software because the data isn't something that's processed. The data is part of the processing. It's part of the program. So if you think about an AI system, it is code plus data, and the data is operating as code effectively because it's telling the system what to do. So the first thing is, have we actually got the talent? But followed up from that is, do we actually understand what we need? Is there a real business case here? And are we going to commit to it? Because one of the big things that I'm sure everybody has seen is that there are gazillions of proof of concepts out there, but very few people are actually committing big amounts to delivering real life projects. And unfortunately, AI really needs you to make that commitment. So do you have a business case that justifies that commitment? Does it justify the cost? Do you understand the cost, both economic and in environmental sustainability issues? That's why small language models are very much more environmentally friendly than large language models. Do you understand the technology? Um, Another one is, do you have the data? And I appreciate that I'm not the lawyer, so I'm not going to talk about IP ownership, but that is going to be a major source of disputes of all sorts as we go forwards, and is fundamentally going to change the nature of contracts, in my view. I'll leave you the legal team to talk about that. But you need to know if you have enough data to train your system. And if you don't have your data in good shape and you just don't have enough of it, then you shouldn't be embarking on building something. So if you can't do any of that in-house, then can you go out? There's lots and lots of people out there who have gone through and started off being cryptocurrency experts and then turned into metaverse experts and then turned into cryptocurrency experts again and now AI experts. Sadly, a lot of them do not necessarily have the skills that you might want to have. This is much more like a digital transformation program. Now, 80% of digital transformations have failed. So we have a lot of lessons we can learn about how to do this. The AI transformation really requires an understanding of what it is you're building, why you're building, and how you bring the people along with you. So that was kind of a long answer. So hopefully I covered that.
No, it was a long answer, Richard, but it was a good answer. And it also referenced lawyers quite a lot, which gives me a very nice, neat way to segue and start picking on. Give you a bit of a rest. You can take a drink, take a breath. And I think what I'll do is I'll maybe come to you, Ali, next, just with some of the slightly more legal questions. And also, you were obviously, you spoke at a webinar on AI back in May, and obviously quite a lot has happened since then. We now have a different government. Um, are the current government taking a different approach? Is there any new UK legislation on the table after all?
Yeah, thanks, Ian, and good afternoon, everyone. Thanks again for joining us on this session. I think before we look at what the new government is doing, I think it's worth just having a very quick recap of what the previous government's position was on regulating AI. So back in May, we had said that Conservative government, they were not intending on bringing in any new specific legislation to deal with AI. They were taking what they called a pro-innovation stance to it all. They were relying on existing regulators to work within sort of frameworks and existing laws and to publish their own guidance for organisations that fell within their remits. Now, the purpose for doing that, according to the government, was that they wanted to avoid sort of blanket rules that applied to all technologies, regardless of how they were to be used. And I guess the point of that was to try and remain flexible and agile as the technology developed over time. Now, some people sort of felt this was the right approach. They said that it allowed for flexibility. It was attractive to AI companies to actually invest in and innovate from the UK, and avoided sort of laws being put in place that would ultimately need to be changed as the technology developed. But I think a lot of others criticised that approach, and said that it was a lack of clarity, and also the divergence of approaches being taken by the different regulators would make it difficult, particularly for organisations who fell under the remit of multiple different regulators.
Yep.
So that was the position of the previous government. Fast forward to now, the new Labour government, what are they saying? So I think it's worth looking firstly at what was the King's Speech, the first Keir Starmer led King's Speech. So they said in that they will seek to establish the appropriate legislation to place requirements on those working to develop the most powerful AI models. So it seems as though Labour's priority is to regulate the developers of the most powerful AI tools. And I think that does sort of go along with what they'd said in their manifesto before the election, in that they were going to look at bringing in binding regulation on the handful of companies that were making the most powerful AI products. So I think that's quite a contrast to the EU. They are taking a much broader approach in terms of their new EU AI Act. But I think there is legislation on the horizon. I think another area that we might see legislation in the UK as well is to deal with the data scraping and text and data mining issue that we're seeing a lot at the moment. So, and how that interacts with copyright laws and IP laws. Now, some of you may remember that the previous Conservative government had actually started to look into bringing in a new exception to copyright infringement for data scraping by AI tools, but then had to scrap that due to the backlash that it received from the creative industries. But I wouldn't be surprised to see that come back on the statute books. And I think actually last month, a member of the government were quoted as saying that they were working through what we need to do to sort of bring clarity to the AI sector and creative industries, and that something might be proposed by the end of the year. So actually, it might be something, we're in November now, so they're running out of time slightly, but it might be that we hear something on that in the not too distant future. And then the only other point I'd make on that regulatory issue is some of you might be aware, most of you probably won't be aware because I certainly wasn't until I looked it up, but the UK has actually just signed a new legally binding international treaty on AI. So that was signed in September. So that's the Council of Europe's Framework Convention on AI, Human Rights, Democracy and the Rule of Law. Not the catchiest of titles, I must say, but what does that seek to do? As sort of in the title, aims to protect human rights, democracy, the rule of law from the risks that are posed by AI by setting international legal standards. So I think that's interesting to see how that's going to develop. It is a legally binding treaty, so member states, which include the UK, the US, and the EU, will have to bring it into force. In terms of the scope of that convention, it applies mainly to public authorities, and I know we've got some public bodies amongst the audience today, so that's something to be aware of. But also it extends to private actors acting on behalf of public bodies, and also private actors acting on their own behalves. But just bear in mind that the convention does say that in relation to the private actors, it will be for member states to decide how they apply the rules to the private side of things. So that's something to be aware of. It'll be interesting to see what the government does with that. But to go back to your question, is there a difference between the two governments? Yes, there is. We're not seeing it yet. We've not got any new laws proposed yet, but I think they're definitely in the pipeline.
And you mentioned Europe quite a bit there, what you were saying, Ali. I mean, is there still relevance in relation to the European position, given that we're now in a kind of post-Brexit Britain?
Yeah, it's a good question because obviously I mentioned the EU AI Act, and I could spend this whole hour talking about the EU AI, but I don't think the audience would thank me for that. So, what I would say on that though is if it is of relevance or interest to the audience, we have written quite a lot about the EU AI Act, and the previous webinar that we did on that covers it in quite a lot of detail. So, shameless plug here, but we do have a new centralized AI hub on the Brody's website, which includes all of the firm's content on AI. So do check that out. Should our UK-based clients care about what the EU are doing? Yes and no, I guess is the answer to that. It really depends. I mean, obviously, post-Brexit regulations from the EU don't have direct effect in the UK. But where you've got UK businesses who are operating in the EU, then it will be relevant because that AI Act does have extraterritorial scope, like sort of the GDPR, meaning that it applies to any AI systems that are placed in the EU market or which affect individuals within the EU. So that is something to bear in mind. And I think what we will start to see is that even businesses that don't sort of have operations in the EU at the moment, any businesses that do have international or EU-wide aspirations, I think we will start to see them complying or striving to comply with the EU standards anyway, just so that they're up sort of aligned with what is ultimately at the moment the highest standard of regulatory compliance at an AI level.
No, thanks, Ali. That's helpful. And I mean, it just shows you how kind of in a relatively short space of time, really quite an awful lot can happen, particularly in this space and with various changes in political situations globally, Europe-wide as well. That's all been, well, regulatory stuff's not necessarily massively cheery. Let's say Richards was slightly more cheery, although he decided to mention criminal aspects of the whole thing. But now to probably the least cheery aspect of it all, I'll come to Monica to speak about liability and claims and litigation and things that have gone wrong in relation to AI. I'm maybe doing you a disservice, Monica, and you're going to present just a happy tale of nothing having gone wrong and no liability attaching to anybody with anything. But no, given that you work on the dispute side of things, is there anything that you can tell us about kind of recent litigation in relation to IP rights, in relation to AI?
Absolutely. Hello, everyone. And yes, it's quite a bleak picture, I'm afraid, as you anticipated. Yeah, so I think we will. I'll leave it to Ali to speak in more detail about the IP rights that might be in play here and what businesses can do to protect their IP. But in terms of litigation that has arisen, there's lots of litigation going on at the moment in the States in particular, but we are seeing litigation here in the UK, and more is likely to continue. In the field of patents, there's been litigation regarding whether computer implemented inventions can be patented. The recent case of Emotional Perception, AI Limited, the Court of Appeal decided that their music recommendation tool was a computer program and didn't make a technical contribution, so therefore it wasn't patentable. And that was over that was an appeal, a successful appeal from the decision at first instance. So Emotional Perception has indicated it will appeal the decision, but of course that is of particular relevance for companies involved in creating or investing in AI tools, whether or not that AI tool can be patented and therefore can be licensed, and all the other protections that come from having a patent. So that's definitely a space to watch. And then you have the other side of patents as to whether or not non-human inventors, whether an AI can be noted as an inventor of a patent. And we've got the famous case of Dr. Thaler, who has raised cases all over the world trying to register a patent in terms of his AI system, Dabus, and it was held by the Supreme Court in the UK. It went all the way up there that only natural persons can be inventors. So Dabus was not entitled to inventorship rights. Then we have copyright, which is obviously very much important here, very much in play when we're talking about data and scraping. And generally, AI systems are not deemed authors of works they produce, but it's debatable whether individuals who prompt the AI system might be considered to be an author. In terms of the litigation we've got at the moment in the UK, the biggest one, there's various kind of going through the courts, but the one which is set to go to trial next summer in the UK, in the English High Court, is Getty Images against Stability AI. And that's where a text-to-image tool is alleged to have used around about 12 million of Getty Images photographs for its training purposes, allegedly without permission. And the defence, there's a few strings to the defence. They say that the potential copying took place outside the UK, but crucially for our purposes, for IP purposes, that the images created by the AI based in text prompts didn't recreate any part of the copyrighted works, and that any copying that resulted from the insertion of the image prompt was not attributable to Stability AI. And it'll be interesting to see what happens there. Yeah. We've also got various litigations in the States regarding generative AI companies such as OpenAI, ChatGPT, and Microsoft, actions being brought by creatives, writers, and actors, alleging that their data had been used without their permission. And then it was reported a few months ago that Mumsnet, the parents' networking site in the UK, is taking legal action against OpenAI. That's the first case against OpenAI here in the UK. The Mumsnet are objecting to it scraping its website in order to train its large language model and facilitate ChatGPT. So it'll be interesting to see where that one goes.
So a whistle-stop tour, but plenty to keep litigators out of trouble or in trouble. Absolutely. Or keep people in trouble. I'm not entirely sure which way it works, but plenty to keep you busy anyway, Monica. So that's what's kind of going on at the moment. In terms of other kinds of legal liability that, whereas there may or may not be cases at the moment, what other kinds of legal liability would you anticipate could arise from the sorts of use of AI that we're seeing at the moment?
Sure. I suppose we have to differentiate between liability that can arise to someone using an AI system when there's not a contract in place, and one where there's a commercial relationship between an AI supplier and the business. So we'll just looking at the first for now. So AI liability when there's no contract, so it's someone using a driverless car which crashes, or a healthcare app that makes a decision which has an adverse impact on health, or an employer using a recruitment tool which turns out to be discriminatory because the data set it's working from is biased. It's difficult to know where liability stands. There's been no particular liability legislation in the UK on this point, and in theory liability could rest with the creator of the AI, the owner, the operator, the producer of the data sets. So, you're looking at the law of delict here in Scotland. A duty of care is a duty of care owed to the third party, the people who actually use it. And then you've got problems with reasonable care. Is it foreseeable? Is it remote? All the kind of the very interesting questions that us lawyers love to debate in terms of the very kind of fine, the very fine legal points that could arise in this situation. So it's essentially, it wouldn't be an easy case to make. And we've spoken about Europe before, but if we contrast that with the position in the EU, along with the EU AI Act, I also have to get the vowels in the right order there. There's the AI Liability Directive, which is being pushed forward there, and that's really intended to relieve injured parties of the burden of proving non-contractual claims in court. So it counteracts that black box problem. There's a rebuttable presumption of casualty to make it easier for the injured parties to prove the causation element that we're talking about here. So it remains to be seen whether or not that's a route the UK goes down as well.
Thank you. Well, you set Ali up, and I think I'll just kind of work my way back up the panel again. So I'll maybe pop in with you, Ali, again, just with a question that links that, as I say, Monica kind of teed up there in terms of what would you say are the potential IP implications for businesses using or considering using or procuring AI products? And I suppose as part of that, what should businesses be doing to protect their IP when they're working with third-party AI developers or providers?
Yeah, so the IP implications around AI are multifaceted, but they're really, really important. So I think the first thing I'd say, and if it's the only thing that the audience take away from what I've said today, then that'd be absolutely fine by me, is that no sensitive or confidential business or client data should be put into these free-to-use generative AI products. So the online version of ChatGPT, for example, there's no safeguards in relation to what you put into that.
Emphatic nodding from Richard as you were saying that as well. I was
good to get the expert nodding along with what you're saying. So the data that those free versions collect, they are using it to train themselves. And when you think of it from an IP perspective, what does that mean? Well, ultimately, if one of your competitors are then asking that model questions that are relevant and that the model's using your data to give it the answer, is there a potential that your IP is being infringed and ending up in the hands of your competitors? Possibly. So just don't be putting anything into that free versions of the ChatGPT or any other free online versions of the generative AI products. But in terms of ownership and licensing of IP for businesses using AI, there's not really a magic AI solution. I'd say it just comes back to good old-fashioned contract drafting and ensuring that the IP provisions are clear and robust enough to deal with all the different buckets of IP that are relevant. So, for any know-how or copyright material that's going into training the model, the contract should deal with what the restrictions are and what each of the parties can do with that, both during the contract and after the contract, and then the same applying to the output data. And I guess the only slight difference here is where we are talking about generative AI and where that's involved, because I guess you don't necessarily know where the output data has come from and how it's been formulated, and for example, whether someone else's IP has been infringed in creating that output. So I think if you can, your contracts with AI developers and providers get any form of warranty or indemnity protection from the supplier in relation to the infringement of third-party IP through your use of the output data, then that is the ideal scenario. If you can't get that,
do you know from your experience, is that likely to be something that's accepted or?
So I think traditionally in usual software contracts and general sort of development contracts, IP warranties, infringement indemnities, you would expect to see those. But I think what we're going to see, and I think what we've started to see actually, is that's going to be less likely where the suppliers are using some form of generative AI in their product offerings. And so if they are taking the stance that they won't give you any warranty or indemnity protection, it then becomes a risk-based analysis that you're going to have to carry out. What are you actually using the output for? Where is it going? Are you using it on a mass scale? Are you using it commercially? And thinking about what the consequences of that could be. And I think the other point to make about contracts is just ensure that you've got robust confidentiality and data privacy protections in your contracts as well. Particularly if you are using a developer that's building a tool, an AI tool for you, if you're handing over a key know-how or data, then just make sure that the contracts contain confidentiality provisions, data protection provisions. Try and achieve high liability caps if you can in relation to those things. Again, it will depend ultimately on the bargaining power of the parties. If you're negotiating with a Microsoft of the world, you might not get much out of them. Whereas if you're negotiating with a smaller supplier, then it might be more possible. So yeah, I don't think there's a magic wand to all of this. It's just thinking about all the relevant IP that's at play and making sure that it's protected at the different stages of the process.
Thank you, Ali. And I'll just coming back to you on that in a similar vein. Richard and Ali's touched on some of this, but is there anything more that you would say in terms of kind of best practice for business when they're looking to integrate AI products into their operations in order to kind of maximize the benefits that might be available, but also to avoid any common pitfalls?
Well, I think that Ali's advice there was excellent. It reminds me of when open source started to emerge and how that changed it. But again, I go back to the point I said earlier about this combination of code and data, and where does the data come from and who owns the data? And another point that's been made is that you don't know where it came from, and that's one of the big issues. So I think that if you're looking at building something, a slightly different answer is that when you start looking at what you could do in your business or your product or integrate into your product, the use of AI, you've got two choices of what you're looking at. One of which is, are you automating something or are you doing something innovative and new? Now, the standard advice in terms of automation is you need to understand what it is that you're automating. And that might sound obvious, but almost everybody who goes into these kind of exercises doesn't fully understand the detail of it. And that's another element that's very common in contractual things with asking software people to develop software for you, is you don't actually know what you do before you build that software. It's 100 times worse with AI because it's going to happen a lot faster. So that again it's really important. You may end up using somebody else's IP in there by mistake, etc. So that's something you really need to look at. I mentioned earlier this thing about being able to look at 100% of customer calls or 100% of everything because you can scale up. So that's a beautiful example of innovation. And again, this comes back to IP because if you're looking at a business and you're either doing the automate or innovate, and you're looking for things that you couldn't previously do, it becomes really interesting. And there is going to be significant value in your business. And that needs to be put into contracts and protected because that could be hugely transformative for your whole industry. Clearly, whatever you're doing, you need to be reasonably sure that you have the rights to the data that you're using for training. And that, again, I reinforce the thing, don't put stuff into public systems. It will end up emerging in somebody else's, even if it's not there. So it's a very complicated area because we don't really understand how a lot of this stuff works. Hence the fact that there are the really transformative use cases are just not very public. I mean, I had a look at Google published 185 use cases of Gemini earlier in the year, and almost every single one of those was some form of chatbot. And chatbots vary from completely useless to being extremely effective. I've seen a chatbot that was doing full emotional detection for treating people with PTSD, which was absolutely stunning. So you're actually talking to somebody and that person will look down to look at their notes and just ridiculously good, and that they will empathize because they're watching the video. So there's a lot of really exciting things. On the other hand, you've got AI tests like my camera here that keeps zooming around as I move.
I was going to say, is this the moment where you reveal yourself to be a chatbot, Richard? Is that what we're? Is that the big
I hope
moment?
I'm more accurate than most of them. So I do think that there's a lot to be looking at here. And again, if you're doing it in-house, if you're putting it elsewhere, is your training data going to end up somewhere? Do you need IP protection? Now, one of the interesting things is that almost every single software development organization, like outsourced organization, is investing massively in using AI internally to their own processes. So if you are outsourcing in it, it doesn't matter whether you're dealing with somebody like Accenture or whether you're dealing with the shop down the road, they're all going to be using these tools. So you need to ensure that you are contracting with that organization, that code that's generated for you belongs to you and doesn't get used for training somebody else's model or indeed testing. So I do think that there's a lot of things to be looked at, but there's a lot of fundamentals that come before worrying about the contract. Sorry, and that's not dissimilar to any other transformation exercise, as I mentioned earlier.
And I mean, you've touched on some of this, but given the risks that we've all been speaking about associated with AI products, but particularly thinking about risks in relation to things like accuracy, ethics, bias, hallucinations, what steps can businesses be looking to take to mitigate against these risks and to ensure that there is responsible use of AI within their organizations?
Well, one thing is making sure that your data is squeaky clean. And us old folks remember GIGO, garbage in, garbage out. As the old expression that, I mean, it dates all the way back to 1960s before even I was doing software. And garbage in, garbage out absolutely applies. And it kind of amplified. The problem with hallucinations, everybody talks about hallucinations, but hallucinations, the bias and everything else, you can think of an AI system as an amplifier for all of these things. It will take small differences and then hugely magnify them so that it becomes a massive problem. So what can you do about this? Well, one is that you can ensure that your data is good. And one of the biggest problems that enterprises have is that they have something like SharePoint or Box or whatever. I'm sure Brody's has this, which is just full of stuff that just gets dumped. And nobody, you throw it into the lumber room, to use an Americanism. Nobody sorts it out, which means that you have significant issues around timeliness of data. One of the things that LLMs are very bad at is understanding that data gets out of date. So you might have regulatory stuff. It's interesting, Ali, talking about the UK regulatory frameworks. And you may find if you're looking at those or case law or whatever, that it flip-flops according to when you're looking at it. So there may be one judgment one way, then that gets overturned on appeal, and then it gets overturned on appeal again, so it goes back. Now, if the LLM doesn't understand the time order of that, you have a real problem, because if you ask a question, it may just pick up the information at the beginning of that first one that's out of date. I've also read about cases where it was using the plaintiff and the defendant's documents the wrong way around because they were in the time order. So that expands outside of legal into any kind of data. So you might have price lists, for example. If you don't make sure that you've got one absolute source of truth, the chatbot may be giving you out-of-date prices because that's the document that it got trained on first. And that's a really complicated thing to manage. So one of the things is that there is an emerging category of tools in what's called augmented data quality. And augmented data quality tools are looking at this kind of thing. They started by producing documents for call center workers, because it's the same problem. Call center worker has to have accurate data to answer the questions they're getting in from the customers. Same problem with training the AI. So there are tools that are emerging here that are actually really clever about identifying problematic data, sometimes fixing it, or coming back to what's probably the strongest argument, which is human in the loop, which is monitor it, have a person actually checking the results. So
yes.
And what's the strongest advice? Human in the loop where possible.
That's where the value in lawyers remains. We've not been replaced yet. That's we can remain the humans in the loop, even if everybody's saying we should be using AI to do 90% of our work now. There remains a need, Richard, and that's good to hear. That's good to hear. On the just while we're on the subject of risks and pitfalls, etc., back to you, Monica. What would you say that businesses can do when they're adopting AI, particularly in order to try and minimize the risk of disputes arising in relation to that use of AI?
Sure. Just before I get to that, I couldn't pass on hallucinations and this being a webinar with lawyers without mentioning the case of the poor lawyer out in New York who decided to use ChatGPT for his case law for his submissions, and ChatGPT hallucinated, invented 6 cases which he went on to use in court, and he was severely sanctioned by the court thereafter and fined to the tune of $5,000, I think, in addition to obviously all the reputational damage and his name been splashed all over the worldwide media. So yes, don't ask ChatGPT to do your submissions for you, or at least if you do, check what cases it's coming up with. Brand new cases you've never heard of before, which happen to be very favourable to your case. Maybe interrogate those a little bit. But yes, moving on, moving on to disputes avoidance. So if you're a business, you're looking to contract with an AI supplier for an exciting new tool, then that's fantastic. That's brilliant. But make sure you get your disputes avoidance strategy in there from the beginning. So, with any like any sort of contract, there's going to be risks involved in entering into the supply of a new tool, a new system. But there's more risks here because of the pace at which AI is moving. There could be new regulations being introduced, uncertainties about how courts might apply existing legal principles, and and as we've discussed previously, ownership over IP. So essentially, instruct your lawyers from the outset of that process. Make sure that you're mitigating the risk of disputes that may arise by by having those protections inside your contract. So ensuring the specification scope of work is clear, detailed, responsibilities, who are they allocated to, have steps along the way at which you can take stock of what's happening, have the payment split if you can, allocate the risks. We've spoken about indemnities, warranties, that sort of thing already. IP rights, make sure that's in there. And then, for our purpose as well, especially, how will the relationship come to an end? What needs to happen to allow that to happen? Is there a dispute resolution process in there? Should parties try to resolve their disputes outside of court? What's going to happen there? So, investing that time and effort at the outset of the relationship and producing understanding that contractual relationship will help to reduce the chances of a dispute arising if parties are thinking about that at the start, and also, and very importantly, it will help to effectively manage that dispute if it does arise. I'm saying if and not when. I'm trying to be optimistic. If a dispute arises, those safeguards in the contract will help you.
That's appreciated. I was just checking as well, just as we focused on negativity in this webinar, it looks like our numbers have remained relatively constant. So either everybody is doing something else, or there is some interest in some of the slightly more negative aspects of the whole thing. So I think we've kept people at least slightly engaged with that. So that's good. I will move on from the kind of disputes side of things and maybe look a little bit to the future. So if I could maybe come back to you, Ali, and really just to say, in terms of, you've spoken a bit about the kind of regulatory position, about the position in Europe. In terms of other major developments or upcoming developments, is there anything coming up that you think our audience should be aware of?
Yeah, so I think the UK legislative position will be interesting to watch, because I think if the government, the UK government sound bites are to be believed, then we might be hearing a bit more about that even this year. So I think that is definitely one to watch this space. I think the EU AI Act, it starts to roll out next year, so it's got a phased implementation. So most of the stuff comes in not until 2026 and 2027, but there are some obligations that start to roll out from next year. So it will be interesting to see what additional guidance comes out in relation to that. I think we will start to see more come out from the UK regulators, and I think we'll see more of them taking a hands-on sandbox type approach. So we've already seen regulators like the FCA and the MHRA rolling out regulatory sandboxes, inviting sort of organisations that are under their remit in to actively participate in discussions and insights, and basically looking at how AI can be used and safeguarded within that regulatory remit. I think in terms of the legal sector, I know we've got some in-house counsel and lawyers on the call. I think we're probably in the legal sector past the hype phase of AI. I think we've sort of peaked and we're sort of coming back down now to what's a bit more sensible. I think most firms are now taking the time to really identify what the relevant use cases for AI is before taking any major investment decisions. And I think most commentators seem to be agreed that although AI is not going to replace us as lawyers, thankfully we'll all keep our jobs. I think the consensus is that lawyers using AI going forward will undoubtedly be more efficient than those who are not using it. So I think the message is that we do need to embrace it. We get asked quite a lot by clients, is AI the next cryptocurrency or the next metaverse? Or is it actually more akin to a revolution like the internet and email? And I think the consensus seems to be that it is the latter. This is something that's here to stay. It's not just something that there's going to be a lot of chat about and then nothing's going to happen. I think it is already really sort of changing the way that we work and that organizations work. And that's only just going to increase in the future. And then just finally, I think I'll pick up on Monica's point. I think we will see more case law next year on both from a contractual and IP side of things in relation to AI. And I think keeping an eye on the data scraping and copyright aspects of that will be really interesting.
Can I just chip in? I love your point there about crypto and multiverse don't have any immediately differentiating value, whereas AI absolutely is an accelerator and a value creator. So yeah, I think that you're completely correct there. This is real. This is the next internet or whatever.
Always good when somebody on the panel jumps in to say that what you were saying was right, rather than immediately having to say, "Can I just pull you up there, Ali?" And what you just said, I disagree fundamentally. That would make for a much more exciting final kind of 5-10 minutes.
But toes,
I think what I might do, we've got a few questions that have come in from the audience. So maybe just pick up on those. And since I was speaking to you anyway, Ali, I think we've got one here just asking what, in terms of what you've got kind of on your desk at the moment, what are the kind of common queries that you're receiving from clients in relation to AI? What are you seeing kind of coming across your desk just now?
So yeah, we're getting quite a lot of queries in from clients about the legalities of AI and I guess what sort of steps they should be taking when looking at purchasing or procuring it. So one of the things that we're doing is we're helping a lot of clients at the moment update their supplier due diligence questionnaires. So the questions that they should be asking when they're procuring AI, updating their procurement checklists to make sure that they've got appropriate questions in there about all of that kind of stuff. What else? We've also been looking at disclaimer clauses quite a bit in terms of accuracy of generative AI products. So, most of the time we're seeing disclaimers saying that the suppliers will not disclaim all liability in relation to the accuracy of the output and that, if the customer is looking to rely on that output, then that's entirely at their own risk. So it's looking at how to sort of get around that and see what we can get out of that. But again, that comes down to bargaining power in terms of what you're going to get there. Hallucinations, that's already been mentioned. I think what I would say on hallucinations, though, is that, at Brody's, we've been looking a lot at the various legal AI products and testing them and trialing them at the moment. And I think what we have seen is a major improvement from where we were 12 months ago in terms of when you ask these sort of enterprise versions of generative AI products, the legal sector products, rather than ChatGPT just giving you an answer and not telling you where it's come from, the new products that we're seeing at an enterprise level, they're actually giving you the source material. They're giving you links to where they've got the answers from, either in line. So, here's a point and this is where we got this from, or at the end of the answer. And I think that is really improving things in terms of us being able to check accuracy and things like that. IP ownership, that's who owns the output, what the licensing needs to look like. That's been a really hot topic. And then just to clarify, just to get a live example that's just sort of come into my head there actually, we're advising a client at the moment who are procuring the development of a new AI product that's got chatbot capabilities built in. Now, we were asked to review the developer T's and C's to see what it said around IP, and what we discovered was that it didn't include any restrictions on what the developer could do with the training data that our client had provided to basically build the product. So our client was handing over key know-how like decision trees and things that was really important, been built up over many years. And the contract did not contain any provisions in terms of how that was to be protected. It didn't even say anything about what the developer could do in terms of giving it to subcontractors who were helping them build the products. So obviously just a message to anyone who are entering into these types of contracts, make sure that there are provisions in there that deal with all of that are protecting your data, both during the sort of proof of concept phase and after, even if it's unsuccessful, what is to happen with all of that data. It's really important because otherwise, as we've been saying, it could end up that they use that data for future products for competitors that obviously you don't want to be providing. So lots of questions coming in on AI from clients at the moment.
And also such a good answer that it's generated another follow-up question on the Q&A, Ali, that I'll just put to you straight away. Have you seen any interesting drafting about liability for decisions or advice given by AI? Is that something that's been picked up on, saying disclaimer wording or anything like that you were mentioning?
Not really. So we've been looking at sort of sample clauses, and we've come up with within my team, we've come up with basically a library of clauses that we use, and we're advising clients on across across a contract, not just in relation to liability. But in terms of the disclaimer wording, I guess we've also been acting on the supply side, not as much as the customer side, but we have been acting for some developers of the AI products themselves. So with that hat on, I guess what we're saying there is that we should be saying that we're disclaiming liability for the output, because ultimately, if you're using any generative aspect of the AI, we don't want to be nailing our hat to the mast and saying we're going to stand behind this and it's going to be 100% accurate. The customers are going to have to take a view in terms of relying on that. And I think that that's been the case, I think, not just with AI, but just software generally. You would see these types of disclaimers in relation to types of software, open source, for example. So I don't think there's anything particularly sort of novel that we're seeing yet for AI, but I think we are at the early stages of sort of contracts that are dealing specifically with AI. So I think we're just going to see that sort of develop in the coming months and years.
Thank you. I think we've probably got time for one more of the questions coming in the Q&A, and I think this is, well, you tell me if I'm wrong, Richard, but this might be one for you, just because it's more of a kind of market practice type question that addresses ethics and law. So I've decided that you're the guy for that. Have you got any examples, or are you aware of how leading organizations are addressing some of the ethical and legal challenges posed by AI, and what sort of frameworks or guidelines? What are they doing to navigate some of those complexities?
Well, one of the standard exercises is to create a center of excellence on this and the ethics and the ability to put this together. And it's not just about the people implementing, and it's not just about board level. In fact, one of the things that's really interesting is that there's a kind of gap in businesses between board level people who are really concerned about these things and the people executing on it who are aware of the risks. And there's this sort of middle management layer that is trying to go la 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 and ignore it. Because they've probably got enough to do, to be fair. Anyway, so the key thing from my point of view is to put in place a group of people that spans that whole range, that has actual responsibility for it. There's some very interesting things happening with like the guidelines, as well as the Council of Europe. There's actually the World Economic Forum is putting together a set of rules, and they're finding that the people who are key for that is chief legal officers. So I do think there's actually a very strong role here for CLOs, in-house counsel, to work with the entire organization to translate what you might have as like company values, or kind of, which is a little bit fluffy, into something that is a set of rules. But it's more about education and awareness. So being aware of those risks, being aware of the fact that the biased data that you may not be aware of is going to get amplified, as we said earlier. And I think from the best practice I've seen is definitely to do that, have people thinking about it, and then training as well. I mean, everybody loves just being trained and things like this, but I think it's really important for people to be aware of the risk associated with it. And that's another thing is, oh, we're not doing this just because it's ethics. No, we're actually doing this because there's a real genuine risk here. And I've had lots of discussions with people who go, oh, ethics and bias, it's all nonsense. And I say, well, actually, no. What happens if somebody comes back and litigates against you? That's a risk, isn't it? And they go, yes. So packaging it as risk rather than ethics is actually a really good piece of marketing internally for why we need to worry about this.
Yeah, no, I think that's really, really sound advice. Well, based on, I was keeping an eye on our numbers of participants, and they've remained constant, and I don't want to push my luck. And also based on the feedback that we receive for webinars, some of the best feedback we receive is, webinar finished 2 or 3 minutes early. So I'm going to try it, which is, I'm not sure if that's complimentary or insulting, but I'm going to try and get that kind of feedback again here. I'll just check. There's nothing else has come in on the Q&A. The number of participants has remained relatively constant. So unless anyone on the panel has a burning issue that they feel that they want to raise that they haven't had an opportunity to address, then I think what I will do is just thank you, Richard, Ali, Monica, for participating today. Our contact details are there on the screen, but also thank everybody who tuned in and who stayed until the end as well. So thank you very much for joining. You have our details. If there are any questions that you wanted to ask, that you weren't able to put in the Q&A today, please feel free to contact any of us and we will do our best to pick that up afterwards. Equally, if I have a look at the Q&A afterwards and there's anything that I didn't manage to pick up, we'll make sure to follow up. So feel free to contact any of us. I think all of our panelists are perfectly happy to pick up questions. Oh, I thought there was another question there, but it was actually just somebody saying that it was a good webinar. So thank you very much. Thank you very much. And that's us. I'll wrap things up there. Thanks again for taking the time. Thanks again to the panelists, and hope to see you at any future webinars in the series. And there's the plug. The final plug for that Ali was already prompting anyway. So please do have a look at that. Check in on the hub. A huge amount of content there for those of you who are interested in this topic. But thanks again for taking the time, and hopefully see you again soon. Thank you very much.
Thank you.
Thanks all.
Thank you.